Now, Judges Matter researcher Mbekezeli Benjamin joins us for more on this judgment. Benjamin, thank you so much for joining us, sir, and for your time this evening. So it's been 7 years of this case having gone on in the East London Regional Court. And we heard over the last 3 days, Magistrate Twanet Olivier just intricately going through all this evidence. I really want us to focus our discussion this evening on the time that she's taken to go through the evidence before she's giving a verdict on this. Is it common for magistrates to take this long before giving a verdict after hearing all the evidence?
Good evening, Katlego, and good evening to the viewers. Usually it depends really on the circumstances of each case. I think it's worth explaining just the background in the court. Everyone in South Africa has a right to a fair trial, and that's guaranteed by Section 35 of the Constitution. And part of that right to a fair trial, it includes being present when you are being tried, and even when the verdict is being delivered, you must be present in court. The court must explain to you what is going on, and it must explain to you the decision that is taken. So that is why in most criminal courts across the country, the judge or the presiding officer will read the judgment into the record and will make sure that you, as the accused person, understand what is going on in the judgment. And that sometimes will include interpretation of that judgment as it's being read. So there's nothing unusual in that sense. But what the judicial officer usually tries to do is to summarize the key parts of the evidence, especially the evidence that is necessary in making the finding. So they will summarize the witnesses who've testified, they'll summarize the aspects that they've testified on. They'll also assess the credibility of that witness weighed up against the rest of the evidence. And that is also to help you understand why the court arrived at the outcome that it did. And sometimes it may take a couple of hours, it may take a day or so, sometimes it takes 2 days. But in this particular case, considering the complexity of the case, I do think it's a little bit excessive.
And I think really that was my next question to you, to say, is it the complexity and just the volume of the evidence that has led to the magistrate taking so much time and really combing through all this evidence in the way that she is?
Well, look, there are only 2 accused in this case, and the charges are relatively straightforward, and they are really dealt with under the Firearms Control Act, which is something that is not, I think, complex. There is no murder, there is no gruesome case that requires forensic complexity of forensic evidence and multiple witnesses. And in fact, I tried to look back. There were about 4 to 5 witnesses who testified in this case, and so it shouldn't have taken a long time for the judge to, or the magistrate to summarize that evidence. And maybe we can add the factor that this is a high-profile case in the sense that it is happening under the glare of the television cameras, and that often does add a bit of pressure on a particular case. But let's maybe look at the example of previous high-profile cases. A good example is the Oscar Pistorius case. In that case, there were about 20 witnesses that ultimately testified. They testified on everything from ballistics to evidence of blood spatter, complex evidence of forensic analysis, and then there were some credibility witnesses who came to testify. And in all of that, the judge was able to read out the judgment and summarize that evidence within 2 days. So even if you consider the glare of the media, both locally and internationally, I don't think that it justifies sitting in court for 3 days to hear the judgment.
But is there a legal or a procedural requirement for magistrates to deliver their verdict within a certain time frame after hearing the evidence?
Well, look, delivering the judgment must happen within 3 months of the last hearing. And for that reason, the Magistrate Olivier is perfectly on time. The case was, or the judgment was reserved on the 21st of June. And so now, right now, on the 29th of September, it's just 2 months or so. And so she is on time in terms of delivering it. But when it comes to actually reading out the judgment, it really depends on the presiding officer. Some presiding officers are quick, others are not so quick, and really it's the pace and style. And so we can't criticize her on the ability to read or the fast or the speed at which she's reading. But I think the level at which she is going into quite detailed evidence on almost every witness that has testified, that might be a little bit, well, it could have been curtailed in some places. It could have been curtailed, especially because these are lay people not trained in the law who are sitting in court waiting for their verdict. And so it's not something that should take so long for a case that is relatively straightforward, particularly because sometimes, yes, people are anxious and they want to hear what the outcome is, but it's important for the court to explain properly how it arrived at that decision. But a balance has to be struck between going into so much detail that everyone is lost in the milieu of evidence, but at the same time being thorough enough for people to follow. I think that balance is careful. Well, it needs careful consideration, and so we assess it in a particular context. It's not a general rule.
Mbekezeli, could it also be that in 2023, the magistrate had ruled against Malema's application in the case being discharged? He in fact accused her of corruption and incompetence, for which judges matter actually condemned him in the strongest terms. Do you think that maybe she is taking this route of intricately going through this evidence so that she's not seen to be biased in any way?
No, that shouldn't really be a factor. That was something that happened, and the case went on, right? The hearings continued, the full trial was dealt with, the defense led its evidence, and there was no point at which she indicated any sort of discomfort arising from that incident. And so I don't think that it should be a factor that should be weighed up in this judgment. And I don't think that there is any reason to actually impute bad faith on the magistrate, to assume that she is acting out of a bribery or any sort of a capture or those kinds of allegations. I don't think that there is any evidence of that nature. And there wasn't even evidence in 2023, which is something that we were quite strong to say. If you have criticism against a judicial officer, bring forth the evidence of why you believe that they are corrupt or that they are captured. And since then, there hasn't been any of that evidence. But it is fair to look at the conduct of the judicial officer, especially in reference to their constitutional obligations, because a judicial officer is supposed to be diligent in terms of the code of conduct. They're supposed to make sure that the trial starts and ends without unreasonable delay, because that is also a right enshrined in the Constitution. So in reference to those specific aspects, I think criticism can be laid against a judicial officer who takes an unreasonably long time to deliver their judgment. But I don't think that it should rise to the level of calling them corrupt or captured or any allegations of that nature, especially without any evidence to back them up.
So yesterday, the EFF SG, Marshal Dlamini, in addressing some of the EFF supporters at the end of the day's proceedings, he mentioned that the magistrate doesn't have a case and that she's wasted their time for the last 7 years. Sitting from your vantage point, do you think there is a case here? And how do you think, hearing how she's going through the evidence, how do you think the verdict will sway?
Well, look, let me first explain, Katlego, that there's not a single magistrate in South Africa who has a case or doesn't have a case. There's no judge who has a case or doesn't have a case. It is the prosecution that brings a charge against someone. The prosecution will prove that charge with the evidence, and they will make their arguments. The defense or the accused has an opportunity to rebut any of that evidence. The role of the presiding officer is to assess both sides and come to a verdict that is in line with the law, in line with the facts, and in line with justice. That is the role of the judicial officer. The role of the judicial officer is not to make a case for any one of the sides. They are there to preside. And so at this stage, the judgment is still ongoing, so it wouldn't be appropriate for me to comment on the substance of this case. There is still going to be a judgment tomorrow morning, so I leave it to the magistrate to arrive at that decision. But it's important to emphasize that judicial officers do not make cases for people. It is the people who come to the court to ask for the court to make a decision.
All right, Mbekezeli Benjamin from Judges Matter, thank you so much for your time this evening. We certainly are looking forward for that judgment to be handed down tomorrow morning.